Hello, and thank you for sticking around to listen to a lawyer. We'll try to make it as interesting as possible. So today I'm going to be talking to you about finding the green zone for generative AI in e-commerce. Now, when the title Finding the Green Zone was put to me by the great team at Pixelz, the first thing that popped into my head was like that lovely, like neon green, Asta green, lime, color associated, I guess now with Charlie XCX and her album Brat. And for those of you that don't know, Brat girl energy is all about being unapologetically, yourself and embracing the chaos and being authentic. And I love that energy. I love that for you. I think it's really important, especially in e-commerce, especially with mobile-first interactions with younger audiences and consumers. When it comes to AI, it's absolutely okay to be a bit brat, but just let's be a bit responsible and maybe talk to a lawyer first, or maybe watch this presentation, okay? So as Thomas mentioned, I am a lawyer. Sorry for that. After 10 years of working in corporate law firms advising on intellectual property and artificial intelligence, I've been advising on AI for about 6 years now, specifically generative AI. I decided to quit earlier this year and become a consultant solicitor where I'm a freelancer, which means I get to pick my own clients. And I choose you all. I choose media and creatives, and it's been great. On the screen here are a couple of things that I've done over the last 18 months, and that's me at last year's flow. So thanks for letting me come back. Now, we've just heard Faye and Chris talk about artificial intelligence. I think everyone in the room here has a good idea of what AI means and what AI is, right? I have here the definition from the EU AI Act, which I'll come on to. AI means a machine-based system designed to operate with varying levels of autonomy and may exhibit adaptiveness after deployment and for explicit or implicit objectives. It infers from the input. Is anyone paying attention anymore? It's going on. No, it's just a computer program that does things that only humans could do, okay? GenAI is a special subset of AI. It uses its training to create new stuff. I want you to imagine a little AI algorithm wandering around London. It's going to some galleries, it's going to some museums, it's going to a concert in Shoreditch, it's going to go hang out at the BBC radio. It is soaking up all of the content, it's learning from it. And then it's going to go home, sit down at its little desk, and then it's going to, using its inspiration, using its training, create some new stuff. That's GenAI. 2022, mega year. That's when things like DALL-E, ChatGPT, and other tools were launched for everyone to use. And that's when people started paying attention. At this point, I had been researching GenAI for a couple of years. It was before it was cool. But anyway, that's my street cred. We've already heard a bit about the trends. Again, Faye and Chris have already spoken about that. And we've heard about some of the benefits. Benefits are pretty obvious. The risks, well, to me, they're obvious. That's why people pay me, is pointing out the risks. When we think about finances, if you use AI incorrectly, your brand will suffer financially, whether it's because of customer attrition, whether it's because of disputes, whether it's because you need to call in an IT specialist to redo your whole infrastructure or buy new software, and so on. It can be expensive if you get it wrong. Your brand and your reputation might suffer. Joe, earlier today, spoke a lot about brand and reputation. Your team might get hurt, whether that's the creatives that you have or, there might be some internal discussions about ethics and responsible use. You have to look after your people. And then, of course, your customers. They might feel misled. They might feel manipulated. They might just be freaking annoyed if you use GenAI to create something that doesn't actually reflect what the product actually is. When we look at risks, we can look at them in specific categories. I tend to think of them as either commercial, social, or legal. The commercial ones, we're going to go into a few in a moment. I'm not going to go into social risks, but I do want to pause here and say that these are really important. These are the things that are systemic and impact us, all of us, both individually and as a whole. These are things like displacement of the job market, or indeed things like AI bias and the climate crisis. I mean, we know what's going on in Florida right now. AI is really, really greedy when it comes to energy and water consumption. You might have heard that in order to generate just 100 words, ChatGPT uses the equivalent of 10 bottles of water. That's a lot, right? What I'm going to talk about as well is the legal stuff. That's your contracts, your intellectual property, B2B, B2C, and of course your regulations. Risk number one is commercial. Having a bad business strategy or no strategy at all could include just being wrong about your Gen AI, what it does, what it can't do, and not appreciating its efficiencies or over-relying on it. You might just be wrong about the law. You think that scraping is fair use. And oh, by the way, fair use is a US thing. Here in the UK, we do fair dealing. My personal favorite, adding something like no copyright infringement was intended. Law doesn't care about your intent when it comes to copyright. Lawyers, you don't want to call in the lawyers because we're expensive and we're boring and we confuse everything. And I'll be the first to admit that a lot of lawyers out there are expensive and they do confuse things, but not all lawyers are like that. And then again, back to what Joe was saying earlier, sometimes people just forget to do a vibe check. They are so under pressure to adapt AI without really thinking it through. And this can have some implications, some negative implications in the long run. Another one, I see a lot of this. I see so much of this. You didn't read the room. This means that you failed to appreciate what the other people are going to think about your use of AI, whether that's your customers or whether it's your third parties like your brand partners or your suppliers or your other customers. Again, returning to customers, if you're not transparent about your use of AI, especially when you're dealing with the accuracy and the quality of the content, this can have knock-on implications not just in terms of purchases, but things like the ASA and the CAP code, right? As well as data protection. And again, we have some racial bias that we need to be aware of and climate crisis and so on. And of course, your brand partners, they're not going to be best pleased if you decide to manipulate one of their, let's say you're working with an influencer, for example, you go off and use AI to enhance their look and they turn around and they're like, you've changed my hair. You've removed a scar, which I'm very proud of, or something of that nature, right? We've spoken briefly about some commercial risks. Let's talk about the fun stuff. Let's talk about lawsuits. Okay, right now, there are more than 30 active lawsuits specifically about copyright against AI companies. They focus on either direct copyright infringement or what's known as vicarious or indeed contributory infringement. I'm going to get into that in a second. Direct copyright infringement, it means you copied something without permission and you shouldn't have done it. Okay. Vicarious or contributory infringement, this is where you benefit from someone else's infringement. So I didn't actually do it, but I'm benefiting in a way from it. Okay. The key question is whether or not training algorithms on copyright protected material, whether or not that is an infringement. Does anyone have any thought? I mean, you don't have to say what they are, but do you have thoughts, ideas, instincts about that? If I was to walk around a gallery today and I got inspired by what I saw, and then I went and I did a photography shoot and I took photos that were similar but not exactly the same, that wouldn't necessarily be an infringement, right? It's an open question. And it gets really complicated when you consider the fact that as currently written, the law says that only a human can infringe copyright. So Sam Altman and his friends at OpenAI, one of their arguments is, it wasn't me or my computer developers that infringed AI. It was our algorithm over there, and our algorithm is a computer. It's not a person. So sorry, boom, lawyered. It sounds ridiculous, but it's absolutely true. Only humans can infringe copyright. So this is one of the things that they're putting forward. All this to say, these lawsuits that are still ongoing are going to change what we do with AI. The oldest one is Reuters and Ross Intelligence. It was filed in May of 2020. Earlier this week, the parties yet again submitted a request for an extension of time. It's not even at trial stage yet. Okay, 4 years ongoing, not even at trial. Copyright's an obvious one, but we've got a lot of other things to consider as well. I went through each of these 32 lawsuits, and I looked at the various other things that people are alleging. Top of the list is removal of CMI, copyright management information. That's the artist's name or the photographer's name, that little copyright symbol. Sounds simple, right? But if you remove that information, there's an automatic damage. There are damages that can be rewarded automatically. Any guesses on how much the fines for that are? Removing just the copyright symbol. Any guesses? $2,500 up to $25,000 per violation. Okay, don't do it. I mean, do it if you want, but Trademark infringement, that's another one. This is a real example from our friends at Midjourney. I typed in coffee mug. Can you imagine what Starbucks legal team would think if they saw this on some website, Etsy, whatever? Okay. They probably would not be best pleased. So trademark comes up a lot. And then, of course, we have things like negligence, privacy, publicity, and so on. Okay? It's not just copyright. Another legal risk that we have is staying on top of the new laws that are coming. In the United States, there are about 40 laws being debated in Congress to apply to all of the United States. These include things like the Nurture Originals, Foster Art, and Keep Entertainment Safe, i.e. the No Fakes Act. Americans are great with, and I say this as a dual American citizen, we do these things where we come up with like a word and then we add in words to make it easy to remember, I guess. In the UK, for reasons that might or might not be obvious, the previous government was very pro-innovator, pro-foreign investment, I guess. We didn't want to regulate those lovely AI companies who came over and made jobs, but the new government has a different view. So expect to see new laws in the UK in the next couple of years. In the meantime, laws like the Copyright Designs and Patent Act, as well as the Consumer Protection Against Unfair Trading Practices, those all apply too. But in the meantime, we can look to our more fashionable neighbors across the channel, and in particular, the EU AI Act, which was just passed in March of this year. This law is basically a consumer protection law. Our friends in Brussels wanted to protect individuals as well as society more generally against the risks that AI poses. The fines for non-compliance are steep, up to 30 million euro for violations, or 6% of global annual turnover. This exceeds what GDPR introduced. And yes, it applies to companies that are not based in Europe. If you've got European Union residents reading your stuff, buying your stuff, the law will likely apply to you. It is long. It's 144 pages. Again, double the length of GDPR. The font is tiny. There are no pictures. It's boring. I don't recommend reading it unless you absolutely have to, and I guess I absolutely had to. It covers 7 things. These are listed on the side, but for our purposes today, we just need to focus on the 2. First is transparency. What does that even mean? It means being open and honest and clear with what you're doing about AI. Okay? You have to disclose this and you have to be accountable for it. Importantly, the Act takes a risk-based approach. This means that the obligations are different depending on what type of AI you're using. You might think, well, that's entirely sensible. If you're driving a Vespa, certain rules apply. And if you're driving a massive, huge, military tank, then you're going to take a different approach, right? Problem is that it gets really complicated really quickly. Does anyone have any guesses as to which category of danger GenAI falls into? Is it high risk? Is it minimal risk? Or not? It's actually none of the above. That's a trick question. It has an entirely new category called general purpose AI. I spent the better part of the summer writing about this specific point for the European Audiovisual Observatory. This paper is available later on this year. It'll be translated into French and German in case you want to read it. If you don't want to read it, then just pay attention to this next little bit. Basically, you need to be transparent when you use GenAI. And this, more often than not, means you need to label your content. You need to label it as being artificially generated or manipulated, and you need to provide this information in a clear way that any ordinary person on the street can understand. And you need to give this information at the person's first interaction or exposure to the content. But not always. There are sometimes carve-outs to include if you're using certain tools in certain situations to just modify content. But these are very nuanced points, and I would suggest getting legal advice before you take what's on the slide. Why is the 2nd of August of next year flagged? This is the deadline that you have to get comfortable with this stuff. Because from the 3rd of August, that's when the fines are going to start kicking in. And we already talked, they're steep. All right, so why should you care? It just makes good business sense, I think. If you use AI correctly, then it can lead to better business growth. And you can use AI in a way that gives your company or your brand a competitive advantage through innovation. Again, what Faye and Chris were showing, like that stuff's pretty cool, right? You use AI properly and you get cool results out of it. Also, it's just kind of the law now. It's not sexy, it's not rocket science, but it is important. And doing these things will lead to fewer headaches and heartaches down the line. I also just think it's the right thing to do. What Thomas said at the beginning of today's session regarding the power that images hold for us, I think is absolutely true. And I do believe that we owe it to not only our customers, but our colleagues and indeed our children to be smart about our use of AI. Because what we're seeing now is just the tip of the iceberg. So what do we do with all of this information other than cry into our pillow at night, which I've done sometimes? I think the reason why you guys are here, at least I hope, is because in some way you're probably a bit curious to know about AI. And I believe that curiosity can lead to your increased competence. You'll ask questions, you'll have thoughts, you'll learn, you'll get better, you'll get smarter. So that's a great first step. Human oversight is absolutely critical. Again, back to what Chris was saying, you need to have someone, a person in charge being responsible for what your business is or isn't doing with AI. And indeed, you should supplement your creative teams, not replace them. Now, the next point, record label, this is a mnemonic device. Think of your favorite musician or band. Think about the record label that represents them, and this is the philosophy that you should approach, and I'll tell you why. Record what you're doing with AI. Record what tools you're using, what brief this aligns to. Just write it down on a Post-it note somewhere and shove it into a drawer. I don't care, but I promise you, if you make a note of it, you will thank me later. And then secondly, AI outputs, consider labeling them. I'm not here to tell you specifically what you should label or not. It's not legal advice, but if you do want legal advice, work with a good lawyer. Doesn't have to be me, but if you want to learn more, scan the QR code. You'll see this slide deck together with last year's Flow presentation, and I look forward to chatting to you guys later on this afternoon. Thank you.
Thank you
so much.
Kelsey. Good. Perfect. Thank you, Kelsey. Slido again. Let's move into questions here.
Yes.
Yes. Do the EU regulations apply to copy content as well, or just imagery, videos, etc.?
Yeah, it's a really good question. And actually, it's these kind of basic fundamental questions that I think are really important to flesh out. The answer is yes. The EU regulation does not distinguish us between audiovisual content and copy. So text that's written, it's all captured.
It's all captured?
Yeah, it's all captured under the regulation.
Okay, good. Then this next one here is probably a little interesting as well.
Oh, yeah.
because you did talk about regional difference in legislation, right? For an e-commerce brand that is operating globally and want to use AI-generated visuals commercially, which legislation is the best to follow? US, UK, EU, aka which one's the strictest and will keep us out of trouble?
Yeah, it's a great question. I love it because I've actually studied, I'm an English qualified lawyer, but I've studied all three. EU.
EU?
Yeah, the EU. So the United States is a bit more liberal in terms of its approach. We like free speech. We don't want to regulate, so on and so forth. The EU Act is the one that's in force right now. I would say it's going to be far stricter. Just look at how we've approached data, for example. It's the EU that kind of led the way on that. Let's see what happens with the UK, but for right now, I would say focus on the EU. And remember that too, that the European Union market is 550 million people, something like that. That's how many residents are in the EU. So 500 million people, if you're good with that, you should be good to go generally. That's not legal advice, it's just a general observation.
Okay. Good, cool. Here's a pretty specific one. What about images of real products placed in an AI-generated background? Is labeling needed there as well? And could that answer also depend on which tool is being used to generate this background?
It depends.
It depends.
It depends. Sorry, it really depends because I don't know. I haven't seen the picture, but if the AI generated background contains some sort of copyrighted material, or if the tool being used was not, properly licensed or so on, again, case by case analysis is required. Once you have your business model figured out, once you have perhaps an internal AI policy to share with your creatives, like, hey, you can do this, that, and the other, it's cool. This is something I work with agencies all the time in developing. It really just depends, but. Is there a difference between who we work with?
Yeah, exactly. Is there a difference in your mind, or is there in your mind a difference between who we work with in terms of risk? Are some of these companies better to cover our?
Absolutely. It's a really good question. And one of the things that I've been doing a lot lately is looking at each product's terms and conditions, as well as their kind of general approach and philosophy. And what I do is I typically do like a little table, a nice colorful table that sets out, hey, this is pretty dodgy what this AI company wants you to do or what they protect against. As a general rule, this is not an endorsement. It's just because I've been doing a lot of creative cloud stuff. Adobe is considered to be one of the more safe options, but I say more safe, not like perfectly safe. But yeah, it definitely depends on the tool that you're using.
Okay, good. Here's a specific one as well, the top one here, right? If I'm using GenAI to create an image and I'm adding and editing elements from my own photographs of, let's say, public spaces, at what point does the copyright infringement end?
Technically, again, I'm so sorry to say this, but it does just depend because we have to look at a couple of different issues here. If we're using GenAI to create an image and then you add in your own, the question has to do with like whether or not it's a substantial amendment based on the totality of the image. And then we also have to consider that the copyright infringement usually happens with regard to the training data sets. So again, it's a really technical question. And the more I explain, the more boring it gets. And it's like, I know it's almost lunchtime and people are like, oh God. But the answer to this really is, if you're interested in this, show me a live example and I'll talk to you about it. Anyone in this room, I'd be very happy to chat with you here, online, next week, whatever, about your specific concerns. It's what I do. Just chatting people about risks.
All right, good. I'm curious about your opinion on this. Are legislators moving too slow and not keeping up with the rapid growth of AI?
Yeah. Yes, they are. I think so. And the reason for this is that legislators are not technical experts. They're not business people. They are elected representatives and they've got a lot on their plate. That's not an excuse. It's not a justification. But when you're dealing with things like wars overseas or costs of food or other crises, sometimes it's like, oh gosh, but like we like tech companies, we don't want to overregulate them. And also, there's just like a lot going on. Everyone's really busy. But yes, it also takes a long time to get agreement. You know, the EU AI Act took something like 3 years to agree, 4 years to agree.
Yeah.
So we have the Czech representatives as well to thank for the definition of AI. I'm looking over at you, Alexandra. So it was the Czech government that actually delayed the agreement of the definition of what AI even means. So lots of people coming at it from different angles.
Okay, good, cool. Let's take this top one. Are you familiar with C2PA? What impact would this regulation have on studios and creatives? Seems like this regulation could be worth keeping tabs on for
so C2PA is a great initiative. I hate to be nitpicky. It's not a regulation. It is a volunteer. You sign up to it as an organization. There's no obligation to. You sign up to it. It's an industry body. It's an industry code of practice. We just talked about the fact that legislators are slow. In the meantime, companies are banding together. Different artists groups are banding together, and they're coming up with their own rules to prove customer trust, to do things ethically. So while the lawyers and the legislators are off, wasting time over in the corner, we have things like C2PA, and I think it's a great initiative.
Okay. Top one, just out of curiosity. Do you ever lean on AI as a way of signaling points of interest in lengthy legal documents?
No, I don't. What I do use AI for is doing things like uploading publicly available lawsuits and saying, what's the second most popular thing being mentioned after copyright infringement? So my list of the most popular things, that's what it does. Not for points of interest, because that I think comes down to my knowledge of the industry and like personal interpretation. The AI doesn't know what's interesting or what's not. I do use it to help me fact check things and summarize things though.
Okay, good. A minute left. Let's take the last one, the bottom one. How risky is training a vendor's large language model?
It depends. I'm so sorry. It depends. Who's the vendor? Is the LLM properly licensed? What are you using it for? Are you using it to build a bomb, or are you using it to make a lovely picture? Again, it just depends. But hopefully, even though there's been a lot of caveating and help warnings, I hope that I've given you guys enough information to kind of go away and maybe have a think and maybe have some practical tips.
Yeah. But I guess, do you have a general advice here, right? Would that be when we're talking customers and their data, always just be careful.
I think it's always be careful, but really be transparent.
Yeah.
If you're working with a client who's actually I think that the risk of this particular harm is low, or actually I want to move fast, I want to be edgy, I want to push boundaries, have a sensible conversation about it. If they're okay with the risk, maybe you should be too. Have conversations, be open, be transparent, and, when in doubt, seek legal advice.
Thank you. Thank you. Thank you.